Hey everybody, it's Christopher Small, the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Today, I want to talk about what the probate process looks like. Before I get to that though, I want to remind you, if you have any questions related to probate and you want us, or you have something going on with probate related and you want to talk to us about it, you can do so by going to probatemeeting.com. All right, go to probatemeeting.com, you can set up a time to talk with us over the phone for free, probatemeeting.com. Okay, a lot of people want to know what the probate process itself looks like. Today, I'm going to run you through the whole thing. Before I get to that though, I want to sort of just give you a little bit of background and remind you that essentially probate is the process of transferring one person's assets to another person's to another person, right? Basically, so if someone has a bank account and they die, they haven't put a beneficiary designation on that bank account is supposed to go to somebody else. Probate is the process of formally transferring that bank account to the person that it's supposed to go to, okay? Now, the probate process itself is pretty straightforward. It is heavily process driven though. It's heavy on procedure. There's a whole bunch of rules. If you Google in Washington State, RCW probate, just Google that, it'll pop up and you can see all the rules that you have to follow when it comes to probate, okay? Typically, probate is going to be opened with something called a petition for letters of administration or petition for letters testamentary, depending on whether or not you have a will. When you file that, you basically let the court know that someone has died, that there is a will or not a will, who the person is that wants to be put in charge of the probate, and you ask the court to consider opening probate. You also let the court know about outstanding debts. You let them know about asset levels. They need to know these things because the court is going to be making a determination about one important thing, which is called non-intervention powers. Non-intervention powers basically allow the personal representative of the probate to do what they need to do without having to go to the court a lot and ask for permission, okay? So non-intervention powers are a good thing when it comes to probate. All right, so you'll file this petition. Typically you will file an oath, a personal representative's oath, and you will ask the court for an order opening probate. Most of the time, well, if it is clear by the rules who the personal representative is supposed to be, the court will just appoint that person. So like if someone's named in a will, they're automatically the person. If there's not, if there's like 4 people that are out there that could possibly fill this role, then you have to have a hearing. And at the hearing, if nobody shows up or if the court finds that you are the right person for the job, they will appoint you to be the personal representative. Once that happens, you have to give notice to all of the heirs that the probate is opened. You have to give notice to Department of Social and Health Services, DSHS, in case there are Medicaid loans. You have to let the Department of Revenue know. You have to do a couple of other things. And then typically you will start the creditor claim period. Creditor claim period is a wonderful tool that allows you to reduce the time that people can submit debts that are owed against the estate from 2 years down to 4 months. You publish this thing this very specific thing in the newspaper 3 weeks in a row. Then you wait for 4 months to pass, and whatever creditor claims have been presented at that point, if they follow the rules, you pay them, but everybody else, they don't get paid. So that's amazing. So in that 4-month period, you're typically gathering the assets, you're trying to figure everything out, work out the details so that once that time period is over, you can make distributions or begin the process of getting everything in place to make distributions. You're also going to pay taxes and do some things in that time potentially, or wait to pay taxes whenever they're due. And then once that creditor claim period is over, you're sort of free to determine what assets there are, determine and ensure and make sure who gets what, distribute those assets, and close the probate. Okay? So obviously there's some technical things that are in the middle there that you have to do. There's some technical things related to the things that I talked about, but that is the process generally. What's great about Washington State is that the probate process is relatively straightforward, it's relatively easy, and if you do it a lot like we do, it's it's relatively simple. We're heavily process driven here, so we make sure that everything gets done right, it gets done on time, that we are helpful with our personal representatives to make sure that they get stuff done in a timely manner and get stuff done easily. Okay? That's it. As always, if you'd like this video, please hit the like button. If you know someone needs to hear this, please share it with them. If you have a question or comment, please leave it. And if you want to talk more about some specific probate matter or estate planning matter for that matter, you can go to probatemeeting.com, set up a time to talk with us over the phone for free, probatemeeting.com. Okay, that's it for today. As always, I'm Christopher Small. I am the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Thank you for your time. Thank you for your attention. I appreciate you, and I'll talk to you again soon.